Matter is set for trial on 12/15. I've been presented to Ms. Sheffield with a plea of guilty form, which indicates you're going to change your plea of not guilty to guilty to the charge in the indictment. This form is 3 pages, has your name, case number on the first page. On page 3, there are signature lines. And about a third of the way down, there's a sentence that says, I entered this plea voluntarily, and right below that is a signature defendant, and there's a line there with, is that your signature I'm looking at?
Yes, sir.
Okay. When did you sign this?
Just now.
And before you signed it, did Ms. Witt go over it with you and explain everything to you and
Yes,
answer any
sir.
questions? And did you understand that it was an agreement to plead guilty, which means there won't be a trial? The next step in your case would be a sentencing hearing?
Yes, sir.
And when you came here today, is this something you thought might happen?
Yes, sir.
You've been talking about it before?
Yes.
Okay. So you've had enough time to fully consider this matter before making the decision to go forward?
Yes.
And you're entering into this agreement to plead guilty voluntarily?
Yes.
Okay, now page 1 says you're going to plead guilty to the charge of aggravated possession of methamphetamine under 2925.11 of the Higher Revised Code, a 5th-degree felony. And it further states that you understand that the maximum penalty for that could be 12 months in prison. The minimum, if a prison term is imposed, is 6 months. There could be a fine of $2,500. There could also be a license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction?
Clinton County.
Okay, and what's the status of that? Have you?
I just left court there today.
Okay, but what's going on? Are you?
They were waiting to see what you were doing.
I'm sorry?
They were waiting to see what Highland County courts were doing.
All right. Have you, you've not entered a plea or had a disposition yet?
I just discussed with my attorney to plead guilty there too.
Okay, but you haven't yet?
No.
Okay. Well, if you are convicted in both counties, and if you should be sentenced to prison in both counties, then the sentences could be ordered to be served consecutively, meaning one after the other. Do you understand that?
Yes, sir.
Now, are you currently on probation, community control, post-release control, or parole for a felony?
In Clinton County, that's the only other charge I have.
It's just the same charge you just told me about?
Yes.
Okay, all right. Now, under the law, if you are convicted of this offense and if you are to be sentenced to prison, upon completion of your prison term, the law provides that the Adult Parole Authority has the jurisdiction, if they decide to, the right, I should say, if they decide to exercise it, to put you under post-release control supervision for a period of up to 2 years, which means you'll be supervised by a parole officer in the terms that the parole authority sets because the court's not involved with that. And if they do that and they determine that you have failed to comply, then they have the right to return you to prison even though you serve the entire term that was ordered by the judge for an additional period of up to, in this case, 6 months for one or more violations. But if you should commit a new felony while under post-release control, then in addition to whatever sentence a judge in that new case could impose upon you, that judge could also sentence you for committing that new offense while under post-release control, in this case, to an additional period of 1 year, whatever time's left on that period of post-release control, whichever is greater. You understand that?
Yes, sir.
And that would have to be served consecutively as well to that new sentence by law.
Okay.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose a sentence of community control, which means that instead of going to prison, you'll be put under the supervision of a probation officer in the terms ordered by the court. And if during that period of time the probation department felt that you were not compliant, they would file a written notice that with the court, serve a copy on you telling you what the alleged violations are. You would have a hearing. You'd be entitled to be represented by an attorney at that hearing. If the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to 6 to 12 months, fine you $2,500. Do you understand that?
Yes, sir.
Now, the charge in the case alleges in the indictment that on or about April 27, 2022, in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Higher Revised Code. So that's the charge we're talking about, the 5th degree felony with the penalties that I've described. Now, you understand what it is you've been charged with by the state, what they said you did, when, where, and how they alleged you did it?
Yes, sir.
You understand the possible penalties.
Yes, sir.
Now, have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with their advice and competence in this matter?
Yes, I am.
Are you under the influence of any types of drugs or alcohol at this
No,
time?
sir.
Have any promises been made, have any threats been made to get you to plead guilty?
No, sir.
Now, on page 2, towards the bottom, there are a couple of sentences that are printed in bold and underlined that read as follows. Defendant shall enter plea of guilty to the indictment. State and defense jointly recommend community control and substance abuse treatment. Does anyone promise you anything other than that to get you to plead guilty today?
No, sir.
Now, under the law, matter of sentence is up to the judge, not the parties. And so even though there's a joint recommendation from both sides that you should get community control or probation, I'm not required to follow that. So if you plead guilty, once I've heard all the information and evidence is presented at your sentencing hearing, if I decide that's not the right sentence, I could impose a prison term of between 6 and 12 months, a fine of $2,500, and a license suspension of between 6 months and 5 years. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
Right, now, you have certain constitutional rights you must understand before I can accept a plea of guilty from you. First, you have right to counsel, and I appointed Ms. Witt to represent you. Now, that wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So if you decide that you do not want to plead guilty, that you want to defend against this case, then she'll continue to represent you and defend you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, the judge will instruct them on the law, and then that jury would decide by unanimous verdict, meaning all 12 of them would have to agree on whether you're guilty or not guilty. And they would decide whether or not the state proved your guilt by that standard. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning that the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proved your guilt instead of a jury. Do you understand that?
Yes, sir.
Now, under the Constitution, Ms. Sheffield, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. So what that means is that witnesses against you would have to come into the courtroom and testify in front of you and your attorney and anyone else that might be present. After the prosecutor was done asking questions, your attorney would ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes.
Now, under the Constitution, Ms. Sheffield, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena. And that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
Now, under the law and the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can. It's your decision, and if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about that with one exception, and that is if there's a jury trial and you do not testify, the judge does instruct the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty, and that plea of not guilty denied the allegations in the indictment, denied you committed any crime, and it exercised all the rights I just described. You change your plea from not guilty to guilty. That is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it is a crime, that you committed the crime. And that plea waives, gives up all the rights that I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. But without exception, your plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. Waive or give up your right to use the power of this court to compel or force witnesses to be in court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty at trial. And it would waive or give up any right to file an appeal that you think you may have had up until this point in the case. Now, if you should be sentenced to the maximum sentence at any point, then or under other certain limited circumstances, you could file an appeal that would have to be filed within 30 days of your sentencing entry being filed. And finally, it subjects you to being sentenced immediately by the court if that's what the court decides to do. Do you understand that?
Yes, sir.
Now, are you a U.S. citizen?
Yes.
Do you have any questions about the charge or the possible penalties?
No, sir.
You understand them?
Yes.
Do you have any questions about the plea agreement?
No, sir.
You understand it?
Yes.
Do you have any questions about the constitutional rights I've explained to you?
No, sir.
You understand those?
Yes, I do.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes. No, I don't.
Yeah, no questions? Okay.
No, sorry.
Now, do you understand?
Yes, I do understand.
Okay. You were just a little ahead of me. All right. Is there anything you'd like to speak with Ms. Witt about before we go any further?
No, sir.
Have any questions about anything I've explained to you here today?
No, thank you for explaining.
All right, then is it your decision to withdraw your not guilty plea and plead guilty to the charge and the indictment according to the terms of the plea agreement that we've just discussed?
Yes.
All right, then as to the charge, which alleges that on or about April 27, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11 of the Ohio Revised Code, charge of aggravated possession of methamphetamine, a fifth-degree felony, carrying a possible prison term between 6 and 12 months, a fine of up to $2,500, and possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. You can be seated. All right, the court will find that on this day in open court, the defendant was advised of all of her constitutional rights and made a knowing, intelligent, voluntary waiver of those rights pursuant to Criminal 11. Plea is accepted and ordered filed. The defendant is found guilty of the charge. A fifth-degree felony is charged in the indictment. The court will refer the matter to the probation department for a pre-sentence report that will include an assessment for substance use disorder and or mental health treatment. Sentencing will be set for January the 4th, 2023 at 9 a.m. and your bond will be continued. So you won't have to be here on the 15th because the trial's off now. You'll need to go down to probation department today unless you have an appointment the next day or so. Do you have a?
I do have to. I leave here.
All right. Well, you see them and tell them that you pled guilty and that you'll need to make an appointment for a pre-sentence interview so they can get all the information from you and then send the written report to me for review before the sentencing. Anything further, counsel?
No, Your Honor.
No, Your Honor.
All right, you'll get an assignment notice here from the bailiff, and then you'll go down to the probation department.
Okay, thank you.
So thank you.